Judicial nominees: Michael Delaney, nominated to the First Circuit Court of Appeals; Judge Jeffrey Cummings, nominated to the Northern District of Illinois; Judge LaShonda Hunt, also nominated to the Northern District of Illinois; Judge Marion Gaston, nominated to the Southern District of California; Judge Wesley Shue, nominated to the Central District of California; and Monica Ramirez Almadani, nominated to the Central District of California. We welcome them, their friends, and families. Congratulations as well. We have several colleagues joining us to introduce nominees, and I'll turn to them after I introduce the nominees from Illinois. Judge Jeffrey Cummings, District Court for the Northern District of Illinois, received a BA from Michigan State, JD from Northwestern University School of Law, clerk for Judge Ann Claire Williams on the Northern District of Illinois. Judge Cummings then entered private practice in Chicago, where he gained experience in employment law, housing discrimination, and the False Claims Act litigation. He served as both Administrative Hearing Officer for the City of Chicago Commission on Human Relations and Hearing Officer for the Chicago Police Board. In 2019, the judges of the Northern District of Illinois selected him to serve as a magistrate. In his time on the bench, he's displayed an even-handed judicial temperament and dedication to the rule of law. He has an impressive breadth of experience in federal court as litigator and magistrate judge. Judge Cummings, welcome to you and your family. Also pleased to introduce Judge LaShonda Hunt, nominated to the District Court for the Northern District of Illinois. Born in Mississippi, grew up on the south side of Chicago, received her bachelor's degree from the University of Illinois at Champaign-Urbana and her JD from the University of Michigan Law School. After starting her legal career as a staff attorney for the U.S. Court of Appeals in the Seventh Circuit, she clerked for the late Judge Bill Hibbler on the Northern District. Judge Hunt then worked as Assistant U.S. Attorney for the Northern District of Illinois, litigating cases involving a range of issues from the Freedom of Information Act to employment discrimination. Following her time as Assistant U.S. Attorney, worked for the State of Illinois in the Department of Corrections and the Department of Central Management. 2017, she was appointed to serve as a bankruptcy judge for the Northern District. Since that appointment, she's presided over approximately 22,000 bankruptcy cases, 75 bench trials. Like Judge Cummings, Judge Hunt is highly regarded for experience in the courtroom as a litigator and judge. Judge Hunt, congratulations and welcome to you and your family. I now turn to the ranking member, Senator Graham, for opening remarks.
I'm ready.
We will now turn to the introductions of our nominees. We will begin with Senator Sheehan. Pardon me, I did the Irish version of that.
Yes, you just made me Irish in one fell swoop.
That works where I come from. You begin with Senator Shaheen, who is introducing Mr. Delaney. Please proceed.
Thank you very much, Chairman Durbin and Ranking Member Graham. Members of the committee, I am so honored to be with all of you and with my colleague, Senator Hassan, to introduce Michael Delaney from the state of New Hampshire, who has been nominated to the First Circuit Court of Appeals. Mr. Delaney is joined today by many of his immediate family, including his wife, Caroline, his 3 children, Maggie, Katie, and Will, and his father, Arthur. And I know I speak for everyone here when I say welcome to all of you. Mr. Delaney received his law degree from Georgetown University Law Center and is currently the director and chair of the litigation department of the McLean Middleton Law Firm in Manchester, New Hampshire. It is our state's largest law firm. In that role, he's litigated in both state and federal courts, representing both individuals and organizations in government and internal investigations across a variety of complex issues. Before his time in private practice, Mr. Delaney had a 14-year-long public service career as a homicide prosecutor, deputy attorney general, legal counsel for former Governor John Lynch, and finally as attorney general for the state of New Hampshire. Mr. Delaney has also dedicated extensive time to serving the New Hampshire legal aid community, serving on the board of directors of New Hampshire Legal Assistance, the Legal Advice and Referral Center, and the New Hampshire Campaign for Legal Services. In describing his own judicial philosophy, Delaney said, and I quote, "Unquestionably, the most important characteristics are to fairly listen with patience and to ensure that the individuals listening or watching you not only trust that you're listening, but that they can feel it and see it. He's consistently demonstrated the temperament and commitment to equal justice under the law that I believe is necessary to be an excellent member of the federal judiciary. His nomination is supported by former New Hampshire Supreme Court judges, New Hampshire victims' rights advocates, the New Hampshire Chiefs of Police Association, and former state's attorneys general, just to name a few. Judge Susan Carbon, who some of you may remember served as director for the Office of Violence Against Women under President Obama, said, and I quote, "Attorney Delaney was instrumental in forging significant systemic reforms in New Hampshire designed to improve the civil and criminal justice systems for victims of crime," end quote. Former Governor John Lynch, for whom Mr. Delaney served as legal counsel, called him one of the most ethical people I've ever known. He is honest, has candor, and is forthright. And Governor Lynch said he, quote, "simply can't think of anyone more deserving of this position." In talking to former Senator Kelly Ayotte about Mike, she told me that she put forward his name to be her deputy attorney general when she was attorney general. She said, although he was a Democrat and I was a Republican, because I believed he was the most capable person for the job, I put him forward. She said she and Mike had worked on several very difficult murder cases together, and so she knew his capabilities and his good judgment firsthand. Mr. Chairman, Ranking Member Graham, I believe that Mr. Delaney's extensive and varied litigation experience and deep commitment to public service would make him an exceptional judge. I thank you again for allowing me to be here today to introduce him, and I hope the committee will support his nomination. Thank you.
Thank you, Senator Shaheen. Senator Hassan.
Well, thank you, Chair Durbin and Ranking Member Graham and members of the Judiciary Committee for holding this hearing. Thank you, Senator Shaheen, as well. I'm honored to be here today to join in introducing Michael Delaney of Manchester, New Hampshire, to the committee. And I'm really pleased to join Senator Shaheen, Senator Ayotte, and a wide cross-section of Granite Staters in supporting Mr. Delaney's nomination to serve as a judge on the United States Courts of Appeals for the First Circuit. I also want to take a moment to add my welcome to Senator Shaheen's, to Mr. Delaney's family. Caroline, Arthur, Maggie, Kate, and Will, welcome, and thank you for being here today. Mr. Delaney is an incredibly well-qualified candidate to serve on the Court of Appeals for the First Circuit. He has the character, intellect, judgment, experience, and empathy to be an exceptional judge. Mr. Delaney's extensive history of service shows that from day one on the First Circuit, he will be ready for whatever cases come before him. Throughout his career, a career that has included serving as chief of New Hampshire's State Homicide Prosecution Unit, as Deputy Attorney General, as legal counsel to Governor Lynch, and finally as Attorney General, Mr. Delaney has done critical work to seek justice for the people of our state, including helping to create our state's first network of sexual assault response teams, as well as creating a comprehensive state commission on human trafficking. I've also had the privilege of working directly with Mr. Delaney in these roles, including when I was a state senator and then during my first few months as governor. I saw firsthand his calm, rigorous, and unbiased analysis in the midst of challenging and sometimes very intense situations. He is a skilled attorney and problem solver. And countless individuals who have worked with Mr. Delaney agree. His nomination for this role has been met with commendation from a wide variety of New Hampshire and national leaders, including from the New Hampshire Associations of Chiefs of Police, multiple former U.S. Marshals in New Hampshire who served under presidents of both parties, New Hampshire county attorneys, the court-appointed special advocates, or CASA, of New Hampshire, numerous leaders working to combat domestic and sexual violence, and a bipartisan group of dozens of former attorneys general from across the country. The president of New Hampshire's Association of Chiefs of Police wrote of Mr. Delaney, quote, "My colleagues and I found Mr. Delaney exemplified all the best qualities of a prosecutor and officer of the court, as well as administrator of the New Hampshire AG's office. His integrity and honesty is without reproach, and his abilities are unquestionable. Mr. Delaney is not only one who worked diligently in support of public safety in New Hampshire, he did so with fairness, equity, and always consistent with the best interest of justice. 29 past presidents of the New Hampshire Bar echoed those sentiments, writing, quote, "Mr. Delaney is exceedingly qualified and has the professional and ethical commitment with regard for members of the judicial branch," close quote. They emphasize that he has, quote, "professionalism, ethics, temperament, and integrity that would make him a well-qualified judge," close quote. 4 retired justices from the New Hampshire Supreme Court, appointed by both Democratic and Republican governors, wrote to support Mr. Delaney. In addition to his strength as a lawyer, they cited his, quote, "totally non-political," close quote, work in a position of public trust as Attorney General, and noted that his, quote, "character, competence, ethics, and decency are above reproach and widely admired," close quote. If confirmed, Mr. Delaney will serve New Hampshire, the circuit, and our entire country with distinction. I urge the committee to look favorably upon Mr. Delaney's nomination. Thank you.
Thanks, Senator Hassan. As is the custom of this committee, we welcome our colleagues to come and introduce their nominees and know that you have a busy schedule. So if you wish, you can be excused at this point. Thank you very much. Senator Feinstein is going to submit statements of support for the record, but we recognize Senator Padilla to introduce the California District Court nominees.
Thank you, Chairman Durbin and Ranking Member Grassley. It's my honor to introduce 3 outstanding nominees to serve on federal district courts in the great state of California today. First, Judge Wesley Shue. He's the nominee to serve on the United States District Court for the Central District of California. He's joined today by his wife and their 2 daughters. Judge Shue's path to sitting before us today is a story of hard work, remarkable intelligence, and in my opinion, a case study in the American dream. His father fled communist China, traveling 70 miles to the coast with his mother and his developmentally disabled brother as a child. Both his parents immigrated to the United States to attend graduate school at Kansas State University before moving to California, where Judge Shue grew up. Judge Shue earned his BA from Yale University in 1993 and his JD from Yale Law School in 1996, before serving as a law clerk on the U.S. District Court for the Central District of California, the same court where he's nominated to serve today. He later served for a decade and a half as an assistant U.S. attorney for the Central District of California in the criminal division, where he was eventually promoted to chief of the Cyber and Intellectual Property Crimes section, prosecuting hacking and intellectual property crimes. Since 2017, Judge Shue has served as a judge on the Los Angeles County Superior Court, both presiding over family law and criminal court. He's an advocate for Asian American affinity bar associations and the need for more diversity in the legal profession. Given his strong qualifications and his deep experience in the Central District, I know that he will serve the district with distinction. Next, it's my honor to introduce Monica Ramirez Almadani, a nominee to serve on the U.S. District for the Central District of California. She's here today with her husband and her parents. Born in Los Angeles as the proud daughter of immigrants from Mexico, Ms. Ramirez Almadani graduated from the Los Angeles Unified School District before receiving her AB from Harvard University in 2001 and her JD from Stanford Law School in 2004. After school, she served as a law clerk for Judge Warren Ferguson on the U.S. Court of Appeals for the 9th District. From the ACLU's Immigrant Rights Project to the Immigrant Rights Clinic at the UC Irvine School of Law, to the California Department of Justice, to the U.S. Department of Justice, throughout her career, she's gathered extensive experience in immigration, civil rights, employment, and criminal law. And since 2021, she's served as president and CEO of Public Counsel, the largest provider of pro bono legal services in the country. So whether it's been defending low-income immigrant clients or in her capacity representing the United States government at the Department of Justice, she has consistently demonstrated an unwavering commitment to the rule of law. And given her broad range of experience, I know she'll be ready on day one to serve the people of the Central District. And finally, Judge Marian Gaston. She joins us today as a nominee to serve on the U.S. District Court for the Southern District of California. She's here alongside her husband today. Judge Gaston was born in Mobile, Alabama, and earned her undergraduate degree from Emory University in 1993, and then her JD from the University of California, Berkeley in 1996. From 1996 to 2015, she served as a public defender in the San Diego County Office of the Primary Public Defender, where she handled thousands of cases and worked on more than 50 jury trial cases and developed a reputation of being a highly ethical lawyer. In 2015, she was appointed to serve as a judge on the Superior Court of San Diego County and has also become chair of the California Judges Association Ethics Committee. She deeply cares about both the rule of law and the people and parties affected by the law, and she will remain consistent from her seat on the bench for the Southern District. Chairman Durbin and Ranking Member Grassley, this week, as we noted yesterday, confirmed the 100th federal judge nominated by President Biden to the federal bench. That's an accomplishment worth celebrating. In a nation rich in diversity of ideas and races and creeds, President Biden has kept to his promise to create a federal judiciary that better reflects the diversity of the nation that it serves. And today's nominees are just the latest reminder of the progress that we've made and the work that we can continue to make. All three nominees come from diverse backgrounds with different paths to today's hearings. But what unites them all is their commitment to our country and to justice. I'm confident that California will be stronger because of their service, and I urge the committee to support their confirmation. Thank you.
Thank you, Senator Padilla. While the staff rearranges the witness table for our first panel, I will explain to the audience that we divide these hearings into panels of circuit judge nominees, circuit court nominees, and district court nominees. And today, Michael Arthur Delaney is a nominee for the circuit court, and he will be questioned first as part of our first panel. If you just bear with us for a moment, we'll get everything set up. Mr. Delaney, if you'd please approach the witness table. Do you affirm the testimony you're about to give before this committee will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you, Mr. Delaney. Welcome to the Senate Judiciary Committee. Please feel free to introduce family and friends and make an opening statement.
Good morning, Chair Durbin, Ranking Member Graham, distinguished members of this committee. I am so pleased to have the opportunity to appear before you this morning. I want to extend a special thanks to Senators Shaheen and Hassan for that generous introduction. I thank President Biden for the honor of his nomination, and I thank Senator Kelly Ayotte for her support. Joining me today are my wonderful family, my incredible wife of 29 years, Caroline, a public interest attorney who advocates on behalf of abused and neglected children in New Hampshire's child protection system. Our three wonderful children, Maggie, Katie, and Will, of whom I am so proud. Also with us are my 91-year-old father, Arthur, and my father-in-law, Kenan, veterans of the Army and Air Force, respectively, and my two oldest siblings, Bill and Kathy. My other brothers and close family are watching from nearby and afar. We lost my mother, Muriel, just this past fall, and I know she is with us in spirit. My father is a first-generation chief probation officer, and my mother, a middle school guidance counselor. It was their example that inspired me to pursue a career in public service. I began my career in public service as a frontline prosecutor, overseeing death investigations, prosecuting homicides, and arguing criminal appeals to the New Hampshire Supreme Court. In those early years, I wore a pager on my belt at all times, and I responded to homes where violence struck and ended human life. I routinely met with so many surviving family members at those scenes, and I saw firsthand how violence causes unimaginable pain. In court, I attempted to elevate their voices to the attention of judges tasked with rendering fair and impartial sentencing decisions. I later served as Deputy Attorney General and Attorney General for New Hampshire, and in those leadership roles, I drew often from my earlier experiences, and I tried hard every day to advance meaningful change in New Hampshire's criminal justice system and make improvements to our state's multidisciplinary responses to domestic violence and sexual assault. I've been practicing now for nearly 30 years, and I've had a unique opportunity to practice law in many different roles: as a public servant, in private practice, in criminal and civil cases, as a prosecutor, a plaintiff's lawyer, defense counsel, and appellate counsel. In 2013, I joined the law firm of McLean Middleton, where I have practiced for the last decade. I am aware that questions have been raised about a legal pleading I filed in private practice following a horrific sexual assault of a high school student by another student. I represented the student's high school in that matter, and I am prepared to address any questions this committee has about that matter or my record as a whole. I am hopeful this committee will evaluate my qualifications based on the entirety of my 30 years practicing. I am very humbled and honored to appear before you today. In all of my legal pursuits, I have been guided by the rule of law and the interests of justice. And if I have the opportunity to be confirmed as a circuit court judge, I will strive to embody the core judicial traits of fair and impartial decision-making in all cases. Thank you, and I welcome the committee's questions.
Thanks, Mr. Delaney. We'll have 5-minute rounds. I'll start. I noted that you have been graded as unanimously well qualified by the American Bar Association, which is a fine starting point. And then the senators from your state have recounted the numerous individuals and agencies and associations that have also endorsed your candidacy. Very bipartisan and very wide-ranging, I would say, in their depth. You understand the controversy, you've already alluded to it, of your representation of St. Paul's School. We have received a letter, which is now part of the record at her request, from the victim that you mentioned earlier, survivor, Miss Jessie Prout. I wanted to give you an opportunity to respond to what has been written in some newspapers and what you have seen in that letter.
Senator Durbin, thank you for the question. Let me start by briefly talking about my practice, and then I'll move to that case. When I joined McLean Middleton, I joined an education law practice group that represents universities, colleges, and independent schools. So I joined that practice area, and it was about a third of my practice. In connection with St. Paul's School, I represented the school in two related matters. The first was a criminal case where the state of New Hampshire brought a criminal prosecution against Owen Labrie, who sexually assaulted Miss Prout. It was a most difficult case given the national attention it received, and Miss Prout went through in that trial what no one should have to endure. There was a second civil proceeding following the criminal case in which the family of Miss Prout sued the school for failing to protect her. As an advocate, I defended the school in that criminal case. I advised the committee that that civil matter ended with a confidential settlement agreement, which does somewhat impact my ability to communicate about it. But I want to address the pleading you referenced, Senator, at the beginning, if I may. I was an advocate for the school in that case, defending it in the civil case. The school was interested in having the case tried in a court of law and not in the media. And when Miss Prout's family requested the opportunity to proceed anonymously in that case, the school agreed to allow the family to proceed anonymously, provided that the court entered relief to ensure that the lawyers would try the case in a court of law and not in the media. I was an advocate with a duty to represent my client to the best of my abilities. I recognize, if confirmed as a judge, my role will be very different, to fairly hear facts, listen to argument, and impartially apply the law.
Mr. Delaney, there are two elements to, at least two, to Ms. Prout's letter that I'd like you to address specifically. And the first is her allegation of witness tampering, and the second is the effort by you or your client to disclose her identity. Would you address both of those?
Thank you, Senator. Relative to witness interference, I believe that references the criminal case, Senator. As a reminder, my client, the school, was not a party to that criminal case. It was a case by the state who convicted Owen Labrie for sexually assaulting Ms. Prout. As a result, I had a very limited role in that case. I helped the judge schedule a jury view because part of the case, at the beginning of the case, involved bringing the jurors out to the school to see the crime scene. So I interacted with the court in a limited way there, and I observed the trial on behalf of the school. But let me say this very clearly. I did not, in that case, nor have I ever, during my 30 years of legal practice, ever interfered with the prosecution of a case or interfered with witness testimony. It would be fundamentally inconsistent with my duty as an officer of the court. It would violate both state and criminal laws, and it did not happen. Relative to the pseudonym lawsuit, the lawsuit regarding the use of the pseudonyms, Senator, I was an advocate. The school was interested in having the case tried in a court of law, not in the media. The school agreed to allow the family to proceed anonymously at all pretrial stages of the case. I did my job in that case as an advocate, and I recognize, if confirmed as a judge, I will be playing a very different role.
Thank you, Mr. Delaney. Senator Graham.
Thank you, Mr. Delaney, very much. Now, what relationship, working relationship, did you have Senator Ayotte?
Thank you for the question, Senator Graham. I knew Senator Ayotte when we were both very young attorneys. We came together as homicide prosecutors and colleagues in the Criminal Justice Bureau of the Attorney General's office. We spent a lot of time together prosecuting cases, going out in the middle of the night to oversee death investigations. And when she was confirmed as Attorney General, she asked me at that time to serve as the sole Deputy Attorney General of the state of New Hampshire. I know her as a talented attorney. I know her as a dedicated public servant. And I've known her very well through the course of my career based on how we interacted with one another at the beginning of our careers.
Yeah, she gave a very glowing recommendation, which means a lot to me, and I hope the committee will look at her evaluation of your professional capabilities. In that job, I guess you worked a lot with police officers, is that correct?
Thank you for the question, Senator. I did, and New Hampshire is somewhat unique as Attorney General's offices go. Much like the state of Rhode Island, the Attorney General's office has significant authority to prosecute crime. So the Attorney General really does serve as the chief law enforcement officer of the state. In that capacity, I worked side by side with local police officers, police chiefs, and state officials, and certainly had interactions with the United States Marshal's Office, the FBI, Secret Service, and so many federal agencies. Appreciate so much what our men and women in uniform do to ensure.
In that regard, I think your nomination's being supported by different law enforcement groups from New Hampshire, is that correct?
That's correct, Senator Graham. The Association of the 10 county attorneys, lead prosecutors in the counties supported me. The New Hampshire Association of Chiefs of Police supported me. I'm grateful for their support, and I have several letters of support from former U.S. Marshals.
And I guess in the job that you've had, Attorney General, and working with Senator Ayotte, that you've dealt with victims of crime, is that correct?
I did, Senator Graham. I dealt with them routinely. I listened to them as a frontline prosecutor. I advanced prosecutions against individuals that had taken away their loved ones. And when I became Attorney General, I tried to take those experiences and make differences for victims of crime in New Hampshire from a public policy standpoint.
What victim advocate groups are supporting your nomination from New Hampshire?
I've received letters of support from the Honorable Susan Carbon, who Senator Shaheen mentioned served as President Obama's Director of Victim Witness Assistance. I've received a letter of support from Christy Palestino McKinney. She served also nationally for the National Children's Alliance, which oversees quality assurance for the child advocacy centers that provide services for child sexual abuse victims. I've received letters of support from the current State Director of Victim Witness Assistance for New Hampshire, as well as the former Director of Victim Witness in New Hampshire, as well as all of the advocates I worked on the front line with in my career as a prosecutor.
During the civil litigation that Senator Durbin mentioned, your law firm was representing schools and school districts, is that correct?
That is correct, Senator.
All right. Can you assure this committee that if you're a judge, that every victim will be heard by you?
I can assure the committee of that, Senator. I think it is critically important for a judge to hear from victims and from all parties that have been impacted by a case. So I would commit to listening to victims very closely while fairly and impartially deciding the cases before me.
Well, apparently the people who are, close to victims in New Hampshire have confidence in you and your judgment. So I appreciate your willingness to come before the committee, and congratulations on your nomination.
Thank you, Senator.
Thanks, Senator Graham. Senator Kennedy?
Thank you, Mr. Chairman. Counselor, congratulations. Help me understand what I'll refer to as the St. Paul's case, the civil litigation. In the civil litigation, what did the plaintiffs allege?
The plaintiffs allege, Senator, that the school failed to protect Miss Prout from being raped by Owen Labrie. Right. The claims were in negligence and breach of fiduciary duty and Title IX.
And what were the plaintiffs asking for in damages?
They were asking for civil damages in the form of monetary relief, Senator.
How much?
Senator, I can't recall specifically if there was a request made at the onset of the case, and I certainly can't speak to the aspects of the case that involve a confidential settlement.
I'm not asking you about the settlement. I'm asking you about the allegations. Were they in the hundreds of thousands, millions?
I don't recall, Senator, and I don't believe that they necessarily would have had to specify that in the complaint when they filed it.
All right. You were in state or federal court?
This was in federal court in the District of New Hampshire, Senator.
Okay. And at some point, you filed a motion with respect to the naming of the minor. Is that right?
That's correct, Senator.
Tell me about that motion.
The family of the minor.
But tell me about the motion first.
So they filed the motion seeking the protection to proceed anonymously.
Oh, so it was their motion.
That's correct. We had the school had an opportunity through its counsel to respond to that motion, and the school agreed to allow the family to proceed anonymously at all pretrial phases of the case, and asked the judge as a condition of that to require the lawyers to try the case in a court of law and not in the media. We, as the lawyers approached the case, the school's perspective was that the request for the lawyers to try the case in the court of law as opposed to the media was fully compatible with the family's request to proceed anonymously and with privacy.
Okay, so I'm just trying to understand. So the plaintiffs filed in the name of Jane Doe. And then the plaintiffs filed a motion. You didn't file a motion. The plaintiffs filed a motion to continue to ask to continue anonymously. Is that right?
That is correct, Senator.
And then the position of the school, you went to your client, St. Paul's, and said, how do you want to respond? And St. Paul's says, we'll agree to that so long as the plaintiff's lawyers don't try this case in the media. Is that correct?
The position the school took was that they would agree to that provided that the lawyers didn't try the case in the media.
Okay. Was that your position or was it your client's position?
That was the school's position, Senator. I was just an advocate advocating for my client as I had a duty to do.
Okay. So that's what your client told you to file this response. You did. I'm assuming that St. Paul's School was getting the hell kicked out of it in the media. I'm not saying justifiably or not. I'm just stating that as a factual matter. And then what happened?
The judge never got to hear the motion that was filed, Senator, because the family that had filed the lawsuit elected to withdraw the motion before the judge could consider it.
And what was the effect of that?
The effect of that was that the motion that was filed became moot and the judge didn't need to address it and never addressed it. What I can say...
And so the plaintiff continued anonymously?
No, at that point, the family elected to proceed without using pseudonyms, Senator.
So the controversy then is about a motion that the plaintiffs filed that you responded to on behalf of your client, and the motion was never resolved, and the plaintiffs then decided to use real names. Is that right?
I believe that's correct, Senator. Again, my role in the case was as an advocate, advancing...
I get it. That's what I'm getting at. I mean, your job's to protect your client.
I had a duty as an officer of the court to advance my client's interests to the best of my ability, Senator.
What if you'd gone to your client? I'm way over. I'm sorry, Mr. Chairman. This will be my last one. If you'd gone to your client and said, look, well, strike that. I think I understand what happened. Thank you, Counsel.
Senator Lee. Senator Blackburn.
Thank you, Mr. Chairman. Mr. Delaney, I want to stay right there with that St. Paul's case, because this is something of tremendous concern to me, that you would have advised, let's make the name of a minor public. And to me, that is something that borders on being disqualifying. And I read some last night about this case and about the senior salute and everything. I think the Prouts are with us today, and I'm delighted that they are. And I appreciate that Chessie put forward a letter that Senator Durbin has made a part of the record. We are in a time when we do everything we can to protect minors. And we had hearings yesterday in this committee about kids' online safety and trying to protect them from sexual and physical abuse. And thank God the Prouts have a daughter, the older sister, who absolutely decked this guy in the face and gave him a shiner for graduation day so that people had to ask him, what had he done? And in Chessie's letter, she talks about how you met with some of the St. Paul's students prior to the hearing that was going on. So would that be witness tampering? Did you advise them? Did you tell them what to say when they were on the stand?
I did not.
Did you try
Senator.
to soft pedal this?
I did not, Senator.
Okay, what did you advise them to say?
What I advised them, and let me first acknowledge your point, Senator, I observed that criminal trial. What the Prout family went through in that trial was horrific and unimaginable. What no one should have to go through, no one would want to see a child endure. It was awful.
Then why did you take the actions that you took?
In the criminal trial, to get to the question regarding the witness involvement, Senator, the school was not a party to that criminal trial.
So you were explaining this to the students?
No, I didn't meet with the students, Senator.
Okay.
I did not even
You were
know.
observed meeting with the students in a side room.
Yeah, I did not meet with the students, Senator. I did not know the
You did not
witnesses.
try to inform them?
I did not.
Okay, but you felt like that Chessie Prout should have been named from the beginning in that lawsuit. And your filing, you painted the school as a victim and Chessie and her parents as villains. Do you think that's intimidation?
I do not believe there was any intent on the school to intimidate.
Okay. That is your belief of an intent. Okay. Can you sincerely testify before us this morning that this case was not exceptional enough to require anonymity? Because you cited case law in your filing that only in exceptional situations can a court grant a party anonymity. So why should it not be granted to a 15-year-old child? Why would that not be exceptional? Would you not want that for your children?
I would, Senator, and
Then why did you advise otherwise? Were you trying to protect the school?
the school agreed to allow the family to proceed anonymously, provided that there were conditions on the lawyers advocating.
What kind of message do you think your conduct sends to survivors of sexual assault? Young women or maybe young men who have been sexually assaulted. What would happen if they had to come before you on the federal bench? What would they think?
I will commit to this committee, Senator, that I will fairly and impartially.
You know, words have meaning. We look at words. We also look at actions. And last night, as I read this, I was taken aback that you would have thought a minor child who had been sexually assaulted did not deserve protection. I think it is chilling, the message this sends to young women. You would stand up and you would defend St. Paul's, and you would defend Senior Salute, and you would defend those actions, but you would not defend a 15-year-old girl and protect her anonymity. And to me, this is something that is disqualifying in your background. We have judges that I think we've got one right now, Judge Edelman, let somebody out knowing they were a danger to the community, and the person he let out killed an 11-year-old girl at a Stop the Violence picnic on July 4th. And actions like this send a chilling message to young women in this country, and I find it unacceptable, and I will not be voting for your nomination.
Thank you, Senator Blackburn. Senator Tillis?
Oh,
Senator Lee, I'm sorry. That's right.
thanks.
You're right.
Thank you, Mr. Chairman. Mr. Delaney, I want to pick up where Senator Blackburn left off. In your filings, in not wanting to allow the victim to maintain her anonymity, you made the following argument in writing, quote, "A court must balance the plaintiff's interest in anonymity against both the public interest in disclosure and any prejudice to the defendant," close quote. I'm not aware of any precedent that supports this position. It does, moreover, appear to contradict every norm in any courtroom in America with regard to a child victim. I'm not aware of any courtroom in America where a child victim, whether still a minor at the time of the trial proceedings or not, where the victim wouldn't be allowed freely to choose to protect her anonymity. So I'm struggling with this. Can you please explain to me how it is that you think, or that you thought at the time? And normally I defer to nominees in the sense that when somebody has a client to represent, they make arguments. Those arguments don't necessarily reflect the attorney's personal views. But there are some circumstances where lines are crossed, and where an attorney goes beyond the duty and the professional obligation of providing zealous representation and steps into some really murky hinterlands, to put it charitably. Can you please explain to me where you got this formulation? Here you have to balance the interest of any prejudice to this ritzy elite boarding school against a child victim who was still a child at the time of the trial proceedings. Can you explain what balancing that is, where you get that, and how you thought that it was even a decent argument?
Thank you for the question, Senator. As an advocate, the school did agree to allow the family to proceed anonymously.
How kind. It's not something that they bestow. This was something that you were trying to stop, a right that she had that you were trying to foreclose.
And what we did in the case, Senator, is we provided Judge Barbadoro in New Hampshire with an order that had recently been issued by Judge Walton in the District of Columbia, where he had both allowed the sexual assault victim in the case to proceed anonymously, while he simultaneously placed restrictions on the lawyers from speaking about the case publicly. So we asked Judge Barbadoro to adopt a position that had recently been ordered by the federal district court in the District of Columbia. In addition, Senator, there has recently been...
That was not at the same time you were making this argument, that the victim's interests have to be balanced against the risk of prejudice to the institution, an institution that, according to the allegations, and as I understand the facts, an institution that was aware of this senior salute, aware of the fact that it had not just become a tradition of debauchery, but of child sexual predation. What interest is there to balance there?
Senator, the Prout family had just a very strong interest in proceeding anonymously. There's no question about that. the school was asking the court to restrict trying the case in the media while that anonymity was being respected by the court. I will note that if I were confirmed to be a judge, there is recent case law that has been adopted by the First Circuit on this very issue as recently as August of 2022 that sets forth a standard I would be obliged to follow regarding the use of anonymity in court.
Well, yeah, that's great, and I'm not worried about circuit precedent at this point. I'm worried about the argument that you saw fit to make, and I find the argument that you appear there to have been making against anonymity of a child sexual victim who was still a child at the time the trial was taking place particularly confusing, when in another high-profile case involving child sexual assault victims, and the Boy Scouts of America, it doesn't appear that you ever objected to the use of pseudonyms to protect the privacy of plaintiffs who at the time had reached adulthood, unlike Chessie in this case. So how do you account for the different approach in the two cases, one involving a minor female plaintiff, still a child at the time the trial proceedings were taking place, and the other case in which there were several by then mature male victims?
Senator, I don't recall the specific case you're referring to involving the Boy Scouts of America. I would like to simply acknowledge your point that I agree that under existing precedent, it is perfectly appropriate and so necessary for survivors of sexual assault to have the opportunity to proceed in court anonymously.
Okay, my time's expired. I just want to ask one yes or no question, but be very, very brief. So, do I understand you now to be denying that you tried to deny the victim her right to anonymity? Or are you saying you did not do that?
I am saying that the school assented to the family proceeding with anonymity
after you had made this argument,
provided that the judge imposed conditions against the lawyers trying the case in the media.
But that's not the argument you were making there. Thank you.
Senator Tillis?
Thank you, Mr. Chairman.
I'm sorry, my mistake.
Oh.
Senator Hirono
I've had
joined
two
us.
chances.
This is not a three-strike situation.
Mr. Chairman, I ask the following two foundational questions of every witness who comes before any of the committees on which I sit, so I will ask you these questions as a part of my responsibility to ensure the fitness of nominees to take the positions to which they have been nominated. Since you became a legal adult, have you ever made unwanted requests for sexual favors or committed any verbal or physical harassment or assault of a sexual nature?
No, I have not, Senator.
Have you ever faced discipline or entered into a settlement related to this kind of conduct?
No, I have not, Senator.
Although I arrived late to this hearing, and I apologize for that, but I had a conflict. You've been asked, I think, by a number of my colleagues to explain what happened in the case in which you represented the school. And so that I am clear, in terms of the question of anonymity of the survivor in this instance, perhaps you could explain why, on the one hand, it is important to protect the name of a minor in cases like this, and what the countervailing arguments are for how you proceeded.
Thank you for the question, Senator. The importance of anonymity is multifaceted. First, using the name of a sexual assault victim has the potential to both either physically place that victim in danger or potentially result in serious psychological harm. There are also considerations that take into effect whether others similarly situated might not feel comfortable using the court system for fear that their names would be used. Those are considerations of paramount importance to the court. If there are other considerations that are balanced to address the second part of your question, the importance of a fair and impartial trial in court is essential, and there's also the need at the jury phase of a case to ensure that witnesses who are testifying feel comfortable about how they're addressing the jurors. But the First Circuit precedent in this case, Senator, that was just adopted in 2022, makes clear that sexual assault victims are an exceptional case, that they should be allowed to proceed anonymously, that if they cannot proceed anonymously, they should have a right at the beginning of the case under the collateral order doctrine to appeal that to the First Circuit Court. If confirmed, that is the precedent I would be obliged to follow, and I would follow it.
That was not the existing precedent at the time of this case.
That had not been the precedent at the time of the case, Senator, which is why we addressed to the federal court in New Hampshire some recent authority from the District of Columbia that the school believed was supporting its position.
So you are going to be on an appellate court, and generally in an appellate situation, you do not see any of the parties that were involved in the district court. And so in every case, however, especially even in criminal cases, there are real people whose real lives are impacted by what the appellate court, what the appellate judge does. And often for these litigants, it's the worst day of their lives to go to court. So how would you, as a judge, keep the real people behind every case in mind as an appellate court judge?
Thank you, Senator. As a homicide prosecutor, I went into court all the time with victims of horrific violence, oftentimes sexual violence. And I know from those experiences just how important the interaction between a judge on the bench and a victim of crime is. It requires careful listening. It requires an understanding and background in how trauma affects individuals that have been harmed by sexual violence. And so I believe that those experiences in my past have given me an opportunity to see so many judges who interact with victims of crime, assure that their voices are heard and taken into consideration as a judge impartially and fairly ensures that all litigants to any case have an opportunity to be heard and that justice is done based on the application of the facts to the law.
Thank you very much, Mr. Chairman.
Thanks, Senator Rono. Senator Tillis.
Really? Okay. Mr. Delaney, thank you for being here. Tell me just briefly why you want to be a judge. I'm going to get to your experience and how you're moving to a circuit without any past experience. I want to know a little bit about your personal experience to make you feel like you're ready for the job. But you had to know coming into this hearing that the subject that's been covered by a lot of my colleagues would be addressed. So you had to go through probably preparation for the hearing, anticipating that. But just for somebody who has had a successful law practice, why make the move to being a circuit court judge?
Thank you for the question, Senator. I'm informed by my nearly 30 years of experience in public service and private practice in answering your question. On a personal level, I just love appellate law. I've done everything. I've done trials. I've done administrative law. I've worked on appeals. And the ability to ensure that cases are fairly reviewed for error is something I think is an area where I could contribute. I also believe that the opportunity to serve on the First Circuit Court of Appeals, in light of the varied background I've had, is probably the most significant way I could contribute to my country and represent my state on that circuit. And I also, when I think about why I want to do it, I understand that what judges do every day dramatically affects people, some for the good and some for the bad. And if I had the opportunity to be confirmed, I would dedicate the entirety of my mind, my heart, and my body to trying to make it right, knowing that every decision I made was going to impact people.
We've had a few nominees come before our committee, and I haven't heard anybody say anything about dumb tweets or papers or posts, so it looks as though your background on that score seems to be relatively innocuous, not rising to a level of asking you a question. We've had a lot of prior nominees come before the committee. They had a lot of writings. They had a lot of statements about how empathy needs to play a role in your job as a judge. Where do you fit on the notion that either popular opinion or empathy, the wants or needs of activists, should have any role whatsoever in your ultimate rulings?
Thank you for the question, Senator. If confirmed, I would change from being an advocate to adjudicating cases, and I think the areas of influence on a circuit court judge are very defined and narrowed. The facts of the case presented to me, open-mindedness, and hearing arguments from the parties to the case, not people outside the case, and then decision-making that involves clear reasoning and clear explanation for litigants as to why a fair and impartial decision has been made. I don't believe that outside influences have a role in that, Senator, and it's not a place that would guide me if confirmed to be a judge.
Thank you. The last question I have relates to the horrible incident with a police chief losing his life, several other officers shot. I think a review of that said that there were no one problem, but several problems that needed to be addressed. How has that changed in light of that? You were AG at the time, I believe?
I was, Senator, and I believe you're referring to the tragic death of Greenland, New Hampshire Police Chief Michael Maloney, who was shot and killed just days before his retirement, backing up a drug raid that went bad. When I was Attorney General and we lost Chief Maloney, I immediately commissioned an independent group of law enforcement officers to review that matter and ensure that we learned from it everything we could, having lost him in the manner that we did. They adopted a report that called for many reforms of the drug task force that oversaw that raid. We changed leadership in the law enforcement group that was in charge of that raid, and law enforcement as a community went together about fixing the things that had gone wrong.
Thank you. Thank you, Mr. Chair.
Senator Hawley.
Thank you, Mr. Chairman. Mr. Delaney, I've been listening to your answers about your conduct in the St. Paul's case, and I have to tell you, I'm having a hard time following what it is you're saying. You've said now several times that the school only wanted the court case to be tried in a court of law, not in the media. But your attempt to strip anonymity from Chessie was exactly an attempt to try this case in the media, right? It was an attempt to bring her name forward so everybody would know who she was. She's 16. Everybody would know exactly who she was. could look her up, could threaten her, intimidate her. I mean, this was an attempt to put her squarely into the media spotlight nationally, right?
Senator, thank you for the question. I respectfully disagree that the school's intent in trying to require the lawyers to try the case in the court of law was in any way intended to intimidate any of the parties to the case.
How can you say that when you knew full well that a 16-year-old girl would have her name published, would have reporters, no doubt, in her front lawn, would have people following her around with cameras everywhere? Her family's sitting here today. They've already been through hell. Your motion was an attempt to put them through further hell in order to defend your client, right?
Senator, I was an advocate for the school.
I understand that, but as advocates, I have been too. And as advocates, we make decisions, but we're responsible for those decisions. You made a decision here. You made a decision to try to strip a young girl of her anonymity, and you effectively succeeded because you bullied her into it. So she, unwilling to be intimidated by you, went forward and revealed her own name, which took, by the way, tremendous courage. And I'd just like to honor her for her courage in doing that. But you put her to that choice. You did. That was your choice. So that's fine. You made the choice, but now you're accountable for it. So let's have some accountability here. You deliberately did this in a way that would put her at risk, and that was your intent. Have you read the letter that she submitted to this committee?
I have read the letter that was submitted to this committee.
Let me read some of it to you. She says, and I quote, "I remember so clearly reading Michael Delaney's motion from front to back when I came home from my new high school one day, processing what it meant, and then defiantly stating to my parents that after everything I'd been dragged through, from anonymous death and rape threats on the internet to the betrayal of and backlash from my closest friends at school, I wasn't going to let Michael Delaney's dirty tactics bully me, then 16 years old, into shame and silence." She goes on, and this is important. "When survivors of sexual assault, harassment, and abuse come forward to seek some semblance of justice, there is an army of attorneys with a tried and true playbook of tactics to discredit, pressure, and manipulate survivors and victims into silence." Those were the tactics that you used, Mr. Delaney.
Senator, I respectfully disagree with that characterization of the role I played as an advocate in the case. The school agreed to allow the case to proceed with anonymity. I have...
No, you didn't. You filed a motion that specifically sought to strip her anonymity. I have it right here. I've read it, and I've read your reasons for doing so. The school didn't like the time that the parents and Chessie filed their lawsuit. You complain that counsel filed the complaints minute before the clerk of the court's office closed on June 1st, 2016. Well, I'm sorry for you, but I don't understand why your inconvenience about the time should mean that this young woman should have to surrender her anonymity and have her life. She's a survivor of sexual assault, let's not forget. That already happened. You knew that. Why should she have to have her life further destroyed because you didn't like the timing of the filing?
Senator, I represented the school in that case. I did not represent the Prout family. I understood what they went through. The school felt that the request to restrict the lawyers from trying the case in the media was compatible with her desire to proceed with privacy and anonymity.
I don't understand what you're saying. You filed a motion that sought to strip her anonymity. You told the court that it should happen because you didn't like the time at which her counsel filed their complaint because it put your school at an inconvenience. They had to answer reporter questions, you said. Frankly, that seems to me like a small burden to bear after what Chessie went through. So you made the decision. You forced her to come forward. She was brave and did it, and now you're accountable for that. And quite frankly, I'm astounded you've been nominated. I can't believe we're sitting here having this conversation today. And I, for one, will not support your nomination for these reasons. People who put sexual assault victims through this kind of torture shouldn't sit on the bench. Thank you, Mr. Chairman.
Senator Cornyn.
Mr. Delaney, let me ask you a series of questions here. My first question is, did you disclose this case in the questionnaire that was submitted to you for this nomination?
If you're referencing to the 10 top cases that I was asked to disclose, Senator, I did not. In part, disclosing cases that are controlled by confidential settlement agreements is something I think all applicants to this process take into consideration. The other reason it's not in there is after this pleading was addressed, there was very little additional courtroom work in the case before the case settled. So there just wasn't a lot of legal proceedings in this case other than the first motion we've discussed.
Did you think that this would not become an issue in your confirmation hearing?
No, I was aware that questions had been raised regarding it, Senator.
So as I understand it, you filed a motion to remove anonymity from the victim of the sexual assault, but the court never actually ruled on it. Is that correct?
The school did not file a motion to remove anonymity. The school filed a motion assenting to anonymity at pre-trial stages, provided the lawyers were restricted from trying the case in the media. That was the motion that was filed, and it was never ruled on by the judge because it was withdrawn before the judge had an opportunity to consider it.
So it was a conditional motion, conditioned on the court instructing the lawyers not to try the case in the media?
It was a conditional assent to the request to proceed anonymously, provided the judge imposed conditions requiring the lawyers to try the case in a court of law and not in the media.
And so if the court had not ruled on that, that portion of your motion with regard to trying the case in the media, would you have proceeded to seek to identify the victim in the court proceeding?
No, Senator. The school did not seek.
Well, I don't understand your statement then. You said it sounded to me like you're saying you conditioned your assent to anonymity on the court ordering the lawyers not to try the case in the media. And I'm asking if the court had not ruled on that portion of the motion with regard to trying the case in the media, would you have withdrawn your assent to proceeding anonymously?
So that matter was never presented, Senator. My expectation is that if the school did not get the conditional relief that it wanted, given the age of the minor, my expectation is that the case would have proceeded with her using anonymous names. That's my expectation as to what would have happened.
You mentioned a case in the District of Columbia, I believe it was Doe versus Cabrera, that was the precedent that you sought to apply in this case. But in fact, in that case, the plaintiff was not a minor at the time of the incident, and at the time of trial was a 27-year-old. So how is that analogous to the case we're referring to?
It's not analogous relative to the age of the participants. That's a clear distinction you're identifying, Senator.
But on what basis would you argue that an adult, that would be analogous to this minor?
That's not an argument I would have made, and we didn't make that argument. The reason we presented that case to Judge Barbadoro was because Judge Walton had granted anonymity in the case and coupled it with an order requiring the lawyers to try the case in a court of law and not in the media. So the relief entered by Judge Walton was to allow that sexual assault victim to proceed anonymously and to tamper down what the lawyers were doing in the media. That is the request we made of the federal court in New Hampshire. I agree the factual standpoint of that case in terms of the age of the parties was quite different.
Well, the victim in the St. Paul school case the trial against her assailant resulted in a conviction, correct? In the criminal court.
It did. Owen Labrie sexually assaulted her. He was brought to justice by a jury, and he was convicted of that sexual assault.
And did your client settle the civil case by paying the victim money?
This is where I'm bound by my obligations of a confidential settlement agreement, Senator. I'm prohibited, given my duties as an officer of the court, from answering your question.
Is that a court order?
There's a confidential settlement agreement that would prohibit me from addressing your question.
So if I looked at the court records, what would the judgment in the civil case reflect?
You would see a stipulation of dismissal filed by the parties, and you would see nothing about the specific terms on which the case settled.
Thank you.
Senator Cruz?
Mr. Delaney, this hearing's not going well for you. And there's a reason for it. Because as much as you may be concerned that it's not going well for you, it's gone far worse for Chessie Prout. The focus of this discussion began when a 15-year-old freshman was sexually assaulted by a senior as part of a campus custom known as Senior Salute, a game where upperclassmen competed to have sex with younger students. In 2015, the culprit was acquitted of felony rape, but found guilty of misdemeanor sexual assault and endangering the welfare of a child. You've repeatedly said you were just an advocate. You were just representing the school, where the school was St. Paul's, one of the most prestigious boarding schools in America. And yet, in your representation of St. Paul's, it was St. Paul's that was the victim. You portrayed the school that a sitting U.S. Senator, indeed a member of this committee, attended. Former Secretary of State John Kerry attended. Former FBI Director Robert Mueller attended. A member of the Kennedy family and 3 Vanderbilts have attended. And in your view, that school was the victim, not the 15-year-old girl who was sexually assaulted. Your response to Senator Hawley was, I was just representing my clients. Well, I'll tell you, Mr. Delaney, you represented your clients very poorly. Because as a lawyer, if your client is a school and they've decided their strategy is to out the girl that was sexually assaulted while in their care and custody, that school is doing a crappy job, and the lawyer who goes in and says, sir, yes, sir, happy to do it, is doing a lousy job representing his client. Now, just a moment ago, you answered questions from Senator Corner. I actually wrote down a couple of things. Earlier in the day, you acknowledged very kindly that the Prout family, I'm quoting you, the Prout family had a strong interest in anonymity. And then just a moment ago, you answered Senator Corner, I wrote it down again, the school did not file a motion to remove anonymity. Mr. Delaney, that testimony is false. I want to read from the motion you filed that is right here. This is on page 2. The school recognizes that JD has an interest in protecting her anonymity. Now notice you told this committee the Prout family had a strong interest. Oddly enough, the word strong was not in your pleading. You graciously conceded they have an interest. Okay? However, in balancing that interest against the prejudice to the school and the public interest in disclosure, the following common sense measures should be taken to mitigate the prejudice to the school, the victim, elite private boarding school. The school shall be entitled to identify plaintiffs and JD during discovery. Plaintiffs and JD should not be allowed to proceed under pseudonyms at the trial of the matter. You asked the court, strip her anonymity. And you just told Senator Cornyn, I didn't ask the court to strip her anonymity. Why did you give a false answer to Senator Cornyn?
Senator Cruz, thank you for the question. I did not in any way intend to provide any misleading answers. The section of the brief that you're referencing involves the use of a pseudonym at trial as opposed to at pretrial phases of the case. And I'm not aware of...
And so your view is it's common sense, that's the word you used, that a teenager, the victim of sexual assault, should be stripped of a pseudonym. That's just a common sense step.
No, I'm saying that First Circuit precedent treats the use of fictitious names before a jury at a trial quite differently than it does at pretrial phases.
So Mr. and Mrs. Prout are here today. Thank you for coming. You and your daughter have been victimized now 3 times. First, on that horrific night. Secondly, when Mr. Delaney, representing the school, went into court and tried to strip your daughter's anonymity, tried to out her against her wishes. And third, when the Biden administration chose to reward him by nominating him to the Court of Appeals. I would encourage everyone to read the letter that Chessie Prout has filed. And Mr. Delaney, there is a reason why virtually every Democrat has skipped this hearing. They're embarrassed about this nomination. I want to read one paragraph from this letter and ask you a final question. From Chessie Prout. If Michael Delaney is confirmed, if an attorney who has brazenly intimidated a minor victim of sexual assault is given the distinct privilege to serve as a judge for the United States Court of Appeals, you are telling victims and survivors that you not only approve of victim intimidation tactics, you reward their enactors with one of the highest legal appointments in the state of Massachusetts. She goes on to say she made this point to the Biden Justice Department. Mr. Delaney, if this committee votes to confirm you, what message does that tell every other victim of sexual assault, child victim of sexual assault, if seeking to out them publicly gets rewarded with a judicial nomination?
Thank you for the question, Senator. I have spent nearly 30 years in my legal career, half of that in public service. I have tried through my work as Attorney General and as a frontline prosecutor to represent the interests of victims in all that I did. I would ask this committee to consider the totality of my record over nearly 30 years as it reviews my qualifications.
Thank you, Mr. Delaney. No further questions coming from the panel. We appreciate your attendance today. There may
Thank you, Senator.
Maybe written questions to follow up, and if you'll please respond to those promptly, we'd appreciate it very much. Second panel, please approach the table. The nominees would remain standing and take the oath. Please raise your right hand. Do you solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Judge Cummings, I thought you were going to have counsel with you there. I saw her approaching the table. Please proceed. You have 5 minutes to introduce family, friends, and make a statement.
Thank you, Chair Durbin, Ranking Member Graham, and the other members of the committee who are present here today. I want to thank you, Chair Durbin and Senator Duckworth, for your support and your gracious introduction today. I also want to thank President Biden for nominating me to serve on the District Court for the Northern District of Illinois. That is a high point of my professional career. I would not be here today if it were not for my family, and first and foremost, I want to thank my parents, my dad, Nelson, who's watching in Wisconsin, my mother, Marlene, who is deceased a couple of years back. They raised us with love, guidance, a tad bit of discipline, and a lot of inspiration for their careers of public service. I really appreciate them. I love them. I have many other friends and family members who are watching from around the country, including my brothers, Casey and Pat, and my sister, Carol, and many others, and their loving support has lifted me up here today. I want to introduce you to the family members who are here with me, beginning with my wife and my 5-year-old daughter, Lola, who has a tremendous amount of energy. They're the center of my world. I love them a lot. I wouldn't be here without them. I'm also very honored and blessed to have with me my older brother, Steve, my sister-in-law, Kathy, my niece, Danielle, my nephew, Ted, and my good friend, Mike Parham, who's joining us here from Seattle. I can't tell them how much it means to me that they're here with me today. And in closing, I want to thank a number of the people that helped me develop into the sort of judge I am here today. First, there would be Judge Ann Claire Williams. I had the honor to serve as her law clerk for a couple of years, and she is a phenomenal person and an excellent role model, a tremendous judge, and I really thank her. I thank my former partners and colleagues at the firm of Minor, Barnhill, and Galland, who taught me how to practice law ethically and with excellence. I also want to thank the current and former magistrate judges and the district judges on the Northern District of Illinois. They're fantastic colleagues and friends, and they've provided so much support to me, I can't even tell you about that. And then my chamber staff, past and present, they make it possible for me to do what I do. And finally, I want to thank my schools, Northwestern Law School and Michigan State. I send my prayers and my heart to the victims of that terrible, horrific shooting that took place on that campus. Thank you, Senators.
Thank you, Judge. We join you in that expression relative to the Michigan State family and victims. Judge Gaston.
Thank you. Good morning, and thank you, Chair Durbin, Ranking Member Graham, and this esteemed committee, with special thanks to my home state senators, Senators Padilla and Feinstein, and added gratitude for Senator Padilla's warm introduction this morning. I'd also like to thank President Biden for this nomination. It is an honor simply to be here. I am profoundly grateful for my family, to my parents and step-parents, my daughter, my brother Fred, my nephews and nieces, and my in-laws. The world is a better and more interesting place for having each of you in it. Thanks to all of those who have lifted me up in prayer, including my church family at St. Paul's Cathedral in San Diego, my mother and her congregation, my in-laws, Dean and Donna, my friend Talisha, and my cousin Libby. O. Henry once wrote, "No friendship is an accident." To the friends who are with me today and those who are watching from home, including my magnificent law school classmates, thank you for your deliberateness in being in my life, for putting in the work over the years, even though we've all been busy. You are brilliant, loyal, and kind. And to my court colleagues, the judges, attorneys, clerks, court reporters, and bailiffs who have been part of my daily life for almost 3 decades, especially my clerk Abraham and my bailiff, Deputy Dart. The rule of law is essential to our American way of life. One of the ways we effectuate the rule of law is to act at all times with professionalism and respect for the public we serve. Thank you for your integrity, your wisdom, and your humanity. Finally, I offer my deepest gratitude to my husband, David, whose thoughtfulness, in every sense of that word, inspires me every day to be a better human being. I welcome the committee's questions.
Thank you, Judge Gaston. Judge Shu.
Thank you, Chairman Durbin, Ranking Member Graham, and distinguished members of the committee for your time and consideration. I want to thank President Biden for the nomination, Senator Padilla for his recommendation and his kind words this morning, and Senator Feinstein for her support and her service to the nation. I would welcome with humility and honor the opportunity to once again serve the Central District of California and my country, this time as a United States District Judge. I would first like to acknowledge my parents who came to the U.S. on $100 per month scholarships to Kansas State University. That one of their children is here before you shows the American dream is alive and well. My parents could not be here today, but I know they are watching from home, and I want them to know that I love them dearly and I thank them. I also want to thank my sister, her husband, and their children for being in my life. And I want to thank my professional family, the late Judge Mariana R. Felser, for whom I clerked, my co-clerk Matt Close, my former colleagues at Gibson, Dunn & Crutcher, and especially Wayne Barsky, my former colleagues from my time at the U.S. Attorney's Office, and my current colleagues on the Los Angeles Superior Court, especially my colleagues and court staff in the East District. I want to thank the people supporting me here today, Joel Wattenbarger and Ben Hemmons, who have been close friends for more than 3 decades, Steve Andrews, who I've known nearly as long, and Professors Mary Cerati and Mark Shefsky, who my wife and I have known for many years. And finally, I want to thank my family. With me here today is my wife of more than 20 years who serves the public in a different capacity, expanding humankind's scientific knowledge, and our 2 daughters. Fortunately for me, it is currently the off-season in both of their sports, so they were willing to come. I love my family and cannot imagine life without their continued love and support. It is the greatest professional honor of my life to be here today, and I welcome your questions.
Thank you, Judge Shu. Judge Hunt.
Thank you, Chair Durbin, Ranking Member Graham, and members of the committee for considering my nomination. I am grateful to Senators Durbin and Duckworth for recommending me for this incredible opportunity and to President Biden for nominating me. Senator Durbin, thank you for the kind introductory remarks. It took a village to get me to this place. Several of them are here with me today. My mother, Rachel Dykes, stepped out on faith as a young woman and moved from a farm in Mississippi to the big city of Chicago to build a new life. She raised 3 children on her own and impressed upon us the value of education and hard work. My siblings, Lynn and Lance, are watching today from their homes. Our mom is my inspiration. My 3 beautiful and very busy children, Nia, Jeremy, and Brian, are here. Nia is in nursing school, Jeremy is in graduate school, and Brian is a college freshman. They are my heart and my joy. Their father, Brian, is here too. I could not have accomplished all that I have as a working mother without him. His friendship and devotion to family has been a blessing. Other extended family and friends in the room are my godsister, Casey, Nia's boyfriend, Derek, my cousin, Haley, and my cousin, Kelly, and her wife, Becky. And then representing my entire college posse, I have Connie and her husband, Shannon, Carmen and her husband, Mark, Kim and her husband, Kiev. I have so many loved ones viewing remotely. My Aunt Dorothy, my niece Demetria, my cousin Calvin, and my Delta ships from Essence. Time will not permit me to name everyone, but please know that I thank you all for pushing me forward and praying me through. And I give special thanks to my amazing chamber staff, my bankruptcy judge colleagues, and our court personnel. Finally, I want to acknowledge the cloud of witnesses who are cheering me on from above, especially my maternal grandmother, Melvina P. Hall, whose spirit of determination and resilience rests on me, my dear friend and guardian angel, Special Agent Dave Nardella, whose 25-year career in law enforcement and devotion to our country inspires me daily, and my district judge, Judge William Hibbler, who recognized and nurtured my dream to one day follow in his footsteps. Senators, I look forward to your questions.
Thank you very much, Judge Hunt. Ms. Amadani.
Good morning. Thank you, Chair Durbin, Ranking Member Graham, and distinguished members of the committee for the warm welcome. Thank you as well to Senator Padilla for the very generous introduction and to Senator Feinstein for her support of my nomination. I am grateful to President Biden for nominating me to serve as a federal judge in my hometown of Los Angeles. It is the honor of a lifetime to be here today. My grandmother, Teresa Lopez, is not here, but I want to start by thanking her. Despite having only a 3rd grade education, she was very active in her community and was president of her Senior Citizen Center in Northeast Los Angeles. She was my role model. She was smart, curious, had a great sense of humor, and a passion for life that motivated me at a young age to dream big. Fortunately, I am joined this morning by my parents, Salvador and Irma Ramirez. They came to this country more than 50 years ago from Mexico with nothing more than determination and hope for a better future. They showed me and my sisters by example how to always work hard, to be diligent and honest, to treat everyone with dignity and respect, and to appreciate and never take for granted the countless blessings this country has given us. Also with me is my best friend, my partner in life, my husband, Yassin Al-Madani. We met as federal prosecutors trying cases, and together we formed a beautiful family. Our 3 young sons, including our 10-month-old son, are back home in Los Angeles with my amazing father and mother-in-law, Farouk and Seyda Al-Madani. They are like parents to me, and I am beyond grateful to them and my children for their unconditional love and support. I also want to briefly thank my sisters, Cynthia Ramirez and Gina Ramirez, my brothers-in-law, my nephews, my niece, my aunt Leticia and uncle Robert Haudicki, and my cousins Lena Haudicki and Olivia Madrigal for being an essential part of my life and for always supporting me professionally and personally. Finally, I would not be here today without the support and teachings of so many dear friends, mentors, colleagues, and classmates. I want to extend my deep, deep gratitude to them as well. Thank you for allowing me this opportunity. I look forward to your questions.
Thank you very much, Ms. Al-Madani, and I'll start with the 5-minute round here by saying initially, Judge Hunt, Judge Hibbler was one of my first recommendations for the federal bench. He's an extraordinary jurist, an extraordinary person, and I think it'd be a great positive experience to have served as his clerk. Can you give us your own shorthand version of the Hibbler philosophy on judging?
Thank you for that question, Senator Durbin. Judge Hibbler was an amazing man who treated all of his law clerks like we were family. I think that if you ask anyone what they remember about him, it was that he was gracious and kind and humble, very respectful. I was fortunate to sit under him and watch the way that he handled himself in the courtroom, that he handled himself at settlement conferences, and really how he treated the litigants who appeared before him. It says something about him that criminal defendants who he had sentenced would write a letter thanking him afterwards because he treated them with such dignity and recognized their humanity. That is the primary lesson that I try to take with me every day since I have been on the bench as a bankruptcy judge.
And that's the point I'm glad you raised, because I think it's so important. These are lifetime appointments. I think you all understand that, which means that if you win the approval of the Senate, now that you've had the nomination of the president, there could be critics, and there will be, I'm sure, but this is your life's calling at this moment. And I've seen judges that have used that graciously, as Judge Hibbler did, and in my terms of practice, I've seen the opposite. Judge Cummings, you've seen a lot of courts and courtrooms, both as a litigator and as a judge. The demeanor of the judge is an important factor, is it not?
Yes, thank you for that question, Senator. I think the demeanor of a judge is incredibly important. Number one, in terms of treating everyone who comes into that courtroom with respect and dignity, and the parties, the attorneys, and with respect to the attorneys, expecting the best out of them, and showing that by your example of always remaining with a calm demeanor in a professional way and not letting your emotions run away with themselves. I think it's also very important for a judge to project humanity to everyone who comes before him or her, whether it's in a naturalization ceremony or it's in an arraignment, initial appearance in a criminal case, or whether it's in a settlement conference. It's very important for the judge to have a human connection with the litigants, and the attorneys who appear in front of him or her.
Thank you. Judge Gaston, what's been your experience? You want-
My apologies. Thank you, Senator Durbin. I would echo the sentiments of Judge Cummings. I think that it can be easy for us to think of procedural due process as something as a dry academic exercise. But what experience shows us is that when people come to court and feel that they have truly been heard, they are willing to accept the outcome. People don't necessarily expect in every case that they bring to be successful in the outcome, but they do want fairness. They do want a chance to have their day in court, and I think that is fundamental to the rule of law.
Judge Shue, I would like your comments as well, but I certainly am struck by your parents' decision to come to America for the princely sum of $100 a month to go to college. If you would like to comment on your parents or your role as a judge, I'd appreciate it.
I'm so grateful to them. I'll leave the judge question because I don't think I could answer it any better than Judge Cummings and Judge Gaston and Judge Hunt just did. I agree with you that demeanor is incredibly important, but I am so grateful for my parents that they, both of them independently, made that huge leap of faith coming to a country they knew nothing about to start essentially a new life. I heard my father recently describe himself to someone as just an ordinary guy, and I had to tell him, you are not an ordinary guy. He accomplished more, at the age of 9 than I can hope to accomplish in my lifetime.
That's a great comment. Ms. Almadani, would you like to comment on the judges that you have had an experience in the courtroom with?
Thank you for that question, Senator Durbin. I've been very fortunate to appear before many different judges in the Central District of California and in front of the Ninth Circuit Court of Appeals. I have found that those judges who listen to the parties' arguments, who do their research, who come prepared, are the judges that we most appreciate. And so, unlike my fellow panelists, I have not served as a judge. I recognize that. If I am so honored as to be confirmed as a judge, that's the kind of judge that I would be, someone who faithfully applies the law, who's open-minded, who listens to the arguments and gives the parties an opportunity to be heard.
Thank you. Senator Graham.
Thank you very much. Judge Gaston, I believe you wrote a paper or an article, I don't know how to describe it, for the California Coalition on Sexual Offending regarding residency restrictions for convicted sex offenders. Is that correct?
Yes, sir.
Okay. What is the California Coalition on Sexual Offending? What is that?
Thank you for the question, Senator. The California Coalition on Sexual Offending is a multidisciplinary nonprofit group that has as its goal the end of sexual assault.
Okay. What was in your paper, you suggested that limiting residency requirements of sex offenders, certain statutes, can't live near schools and other things. You didn't agree with that, is that correct?
Thank you again for the question, Senator. I did co-author that position paper in which a group of us asked the legislature to take a look at several proposals, including residence restrictions. Our fear at that time, along with the fear of our allies in the victim rights community and in law enforcement, was that in some cases, the residence restrictions were actually hindering public safety, which of course was the opposite of of the goal.
How does it hinder public safety?
In some instances, residence restrictions resulted in convicted sex offenders being homeless, which presents a huge challenge to law enforcement.
Well, the statutes don't deny people the ability to live at all. It's just restrictions around schools and places where children gather. Is that correct?
Yes, sir.
I think here's a line. Difficult as it might be, laws that regulate where sex offenders may not live should be repealed or substantially modified in interest of public safety. I still don't understand how that makes you homeless.
Thank you for the question. I think it was an unintended consequence of some of these laws.
So are you saying that if we don't allow sex offenders to live in areas where children gather like schools, that we're creating a homeless problem?
The position of that paper, again, an allyship with law enforcement and victim rights advocacy groups.
What law enforcement groups were pushing this?
There's parole and probation in San Diego were having a very difficult time at that time monitoring sex offenders as they were required to do.
Why were they having a difficult time monitoring sex offenders?
I think the way that they would put it, Senator, is that a homeless sex offender is more difficult.
I don't buy the proposition that a legislative body saying registered sex offenders. Are you okay with registering sex offenders?
Pardon me?
Are you okay with a registry for sex offenders so the public knows what this person did?
Sex offender registration is the law, Senator.
Are you okay with that?
Whether or not I am or not as a sitting
No, wait a
judge.
minute. It's really important to me because the point I'm trying to make here is the argument that the laws restricting where a registered sex offender can live leads to homelessness makes zero sense to me.
Right.
Thank you.
Senator Hirono.
Thank you, Mr. Chairman. Before I ask my first question, I would like to congratulate all of the nominees. I think you are all well qualified. But, Mr. Chairman, I would like the record of this morning's hearing to reflect that when my colleague from Texas said that no Democrat was attending the first panel's hearing, I was sitting right here. I suggest he get his vision checked. My questions. These are two questions that I ask of every nominee on any of the committees on which I sit. These are foundational questions to ensure the fitness of the nominee for the positions to which you have been nominated. And we'll just start with Judge Cummings and go right down the line. Since you became a legal adult, have you ever made unwanted requests for sexual favors or committed any verbal or physical harassment or assault of a sexual nature?
No, Senator.
No, Senator.
No, Senator.
No, Senator.
No, Senator.
Have you ever faced discipline or entered into a settlement related to this kind of conduct?
No, Senator.
No, Senator.
No, Senator.
No, Senator.
No, Senator.
Mr. Chairman, I yield the rest of my time. Congratulations to each of you.
Thank you, Senator. Senator Kennedy.
Thank you, Mr. Chairman. Congratulations to each of you. Judge Gaston, on December 6th, 2008, you talked about this with Senator Graham. I'm going to quote, children are not safer because registered sex offenders are prohibited from residing near schools, parks, daycare centers, and other places where children tend to gather. End quote. Did you write that?
I co-wrote that article. Yes, sir.
Okay. When you wrote it, did you believe it?
I did.
Okay. All right, let's start back down on this end. Ms. Al-Madani, tell me about this doctrine of qualified immunity that we're discussing here in Congress and in the newspapers.
Thank you, Senator Kennedy. Qualified immunity applies in 1983 cases as well as Bivens actions to law enforcement officers.
Right.
Unless there is a clearly established constitutional violation, they are subject to qualified immunity. They are immune.
Okay, thank you for that. Let's go to Judge Hunt. Judge, what is the standard? I'm sorry, I keep bumping my mic. What's the standard for granting a motion for summary judgment in federal court?
Thank you for the question, Senator. Summary judgment motions in federal court are evaluated under Federal Rule of Civil Procedure 56. The question is whether there is a genuine issue of material fact that will require a trial. The moving party has the burden of proof of establishing that there is no genuine issue of material fact and that judgment should be granted as a matter of law. If the moving party does not meet that burden, then summary judgment is denied and the case goes forward to trial.
Okay. So basically, it's just, are the facts in dispute and is law in your favor?
That's probably a shorthand for it, but really it's, are there material facts in dispute? Because in my experience, there are often factual disputes, but the question is whether they are material to the resolution of the issue.
Otherwise, you wouldn't be in court.
Exactly.
Judge Hugh, tell me about New York Times v. Sullivan.
I believe that was a First Amendment case, Your Honor. I'm sorry, Senator, and about free speech. But in my 5 years of being a judge and 25 years of practice, I haven't had to actually apply New York Times v. Sullivan.
Okay. Judge, well, I talked to Judge Yassen. Judge Cummings?
Good afternoon.
Good afternoon to you, sir. Tell me the rule that the United States Supreme Court follows in deciding whether to overturn precedent.
Thank you for that question, Senator.
You're welcome.
In deciding to overturn precedent, the court looks at a number of factors, including the soundness of the reasoning of the decision in question, the workability of the rule that it establishes in terms of how it is applied, developments that have taken place since the decision was issued, and they also look at reliance that parties or litigants have placed upon that decision in question.
Okay. Let me ask you, well, I'll start back here again. What did the White House give you to prepare for today's hearing?
Senator, there were a number of meetings with the White House counsel's office.
Did they give you any written materials to read?
There were some written materials.
Tell me, what were those?
There were materials that were already in the record, questions and answers from prior hearings.
So they gave you a list of questions and answers from prior hearings?
An overview, I would say.
Yeah. How many questions and answers did they give you?
I'm not sure, Senator. Sitting here, I'm not sure exactly how many questions.
Was it more than 10?
Yes.
More than 50?
I don't believe so.
Okay. And whose questions were they?
They were Senators' questions.
Which ones?
There were some of your questions, Senator.
Were there?
But I also watched many hearings, and so I'm...
Thank you, Mr. Chairman.
That's a tribute to you, Senator.
I'm smiling.
Senator Padilla.
Thank you. I hope that smile translates into a vote in short order. Judge Hsu, you've said that you have wanted to be a judge ever since you were a clerk. You've also said that you believe it is important for litigants to see and know that the bench reflects the community in which they preside. I, along with many of my fellow senators on this committee and throughout the Senate, believe that it's important for our federal judiciary to better reflect and understand the America that it serves. Diversity on the bench helps improve public confidence in the judicial system and can lead to better decision-making overall. But I also believe that it's critical that we promote diversity not just in the bench itself, but also in the profession pipeline to the bench. Judges, too, should strive to help diversify the legal profession, including in the area where they have the most direct control, the hiring of law clerks. These positions can be, without a doubt, and as you may have experienced yourself, pivotal credentials for young lawyers on their way to impactful legal careers. So I'd like to ask each of you, all five of you, beginning with Judge Shu, do you agree that the goal of diversifying the pool of judicial law clerks is a worthwhile one? And if so, what steps would you take to ensure that clerkship opportunities are available to a diverse, in every sense of the word, pool of applicants?
I agree with you, Senator. Thank you for the question. I agree with you that it is critically important to diversify the pool of law clerks. I agree with you that it is an important credential for young litigators to have. I would seek to continue doing what I think I have been doing in my career, which is working with affinity bar organizations to make sure that qualified applicants are not taking themselves out of the applicant pool by showing them that they can do it and that they should apply and that they should structure their career in law school so that they would be qualified and apply for clerkships.
Okay, thank you. And to mix it up a little bit, we'll start with Ms. Ramirez and then work our way back this way.
Thank you for that question, Senator Padilla. I certainly benefited from clerking on the Ninth Circuit. It was an incredible experience, one that I draw from every day. Diversity is critical in the law clerk pool, on the bench, in all different settings because it reflects it promotes public confidence in the institution by showing that everyone has a place at different levels of government in different places. And so I would certainly promote doing outreach to many law schools to encourage a diverse pool of applicants to apply for clerkships. And I would note that there are many different kinds of diversity that are important. And so I think that is something that would be very important to me if I am confirmed as a judge.
Thank you. Judge Hunt.
Thank you for the question, Senator Padilla. I agree also. Diversity is incredibly important, and I would expand that to personal and professional diversity. My law clerks help me considerably, and I have to give them credit for some of the better reasoned decisions that I make because you're able to consider so many other perspectives and life experiences. It helps us as judges, actually, to have law clerks from different backgrounds. I have had law student externs for the summer. That's one of the primary ways that I try to support that initiative because I think so many law students don't know about the opportunity or don't think that they will qualify. And so that is something that I will continue to do.
Thank you. Judge Gaston.
Thank you. In addition to the comments of my esteemed colleagues here, I would only add that I think one way that we could encourage more diverse applicants is by approaching schools that haven't been traditional sources of clerks. And so that's something that I would like to look into.
Thank you. Judge Cummings.
And thank you for your question, Senator. I just think back about how I became a law clerk. One of my law professors asked me what I was going to do after law school, and I said I didn't know. And he said, well, why don't you be a law clerk? And I said, what's a law clerk? I was the first person in my family to graduate from law school, and I had no idea. And that gets to the point of I think it's very important for us to go back to the law schools, to the incoming law students, and even to high schools, and just encourage young people by our example to say, explain what we do, explain that they can do it, and show them an example of someone who may have their background and experience, and they can come forward and take these positions and actually try to become a law clerk. And so that's one of the things I do is speak to students and try to encourage other lawyers to get into the business of becoming a law clerk. Thank you, Senator.
Okay. Thank you to each of you. Congratulations. Look forward to supporting your nominations. Thank you, Mr. Chairman.
Thank you, Senator Padilla, and thanks to this panel of nominees. Questions for the record will be due to the nominees by 5 p.m. on Wednesday, February 22nd. Record will likewise remain open until that time to submit letters and similar materials. And if there's nothing further to come before the Senate Judiciary Committee, we stand adjourned.